Welcome to Employment Law This Week. I'm George Whipple. Today is the first day that newly confirmed Justice Neil Gorsuch will take his seat on the Supreme Court. After more than a year, the court returns to its full complement of 9 justices. Our top story this week: New York City prohibits inquiries into the salary history of applicants. The City Council has passed legislation that bars public and private employers in New York City from asking about or seeking to confirm information regarding any job applicants' current or prior wages, benefits, and other compensation. New York City now joins Philadelphia and Massachusetts in prohibiting inquiries into salary history. Here's Susan Gross-Shalinski with some advice for employers.
There definitely are some challenges for employers in this regard. It's very important to make sure that everybody is informed, not only your internal folks, but any external folks, whether it's your background check vendors, whether it's your external recruiters. Anybody who is going to speak to a candidate on your behalf has to be made aware of the restrictions of this law. Now, you can ask somebody what their expectations are with respect to compensation, and there are some other exceptions like deferred comp being left on the table, things like that. But again, we really have to be very clear with everybody involved in the hiring process that everybody understands the restrictions that are set forth in this law.
Circuit courts should only review the scope of EEOC subpoenas for abuse of discretion by the trial court. That's according to the Supreme Court, adopting a standard deferential to district courts on EEOC subpoenas. In the case in question, an Arizona district court granted an employer's motion to quash a portion of the EEOC subpoena it contended sought information that was irrelevant. The EEOC appealed to the Ninth Circuit, which reviewed the matter de novo and held that the full subpoena should be enforced. The Supreme Court reversed, sending the case back to the Ninth Circuit, where it will apply the newly clarified standard of review. The Department of Labor delays the Fiduciary Rule. The Department has issued a final rule delaying the start date of the Fiduciary Rule by 60 days. The rule, which applies to persons that provide fiduciary investment advice, including advisors and financial institutions, has now been put on hold until June 9, 2017. Other requirements of the rule, such as specific disclosures, are not scheduled to become applicable until January 1, 2018. During this time, the Department plans to continue its review of the rule as directed by President Trump. A district court in Florida has confirmed the broad reach of sarbanes-oxley whistleblower protections. An employee for a management company raised concerns about potentially inadequate information security and problems with financial reporting. The employee was terminated and subsequently brought a retaliation claim against her employer. In a motion to dismiss, the company argued that the employee's concerns fell outside the protection of Sarbanes-Oxley, but the court found the disclosures about the company's perceived weak internal controls were in fact protected under the law. And that brings us to our tip of the week. Andrew Smith, head of employment law for Standard Chartered Bank, is here with some advice on avoiding pitfalls in the recruitment process. We caught up with Andrew at last month's SIFMA conference in San Diego.
I think the main issue in recruiting today is the evolving nature of the laws that affect it. Things like gender equality laws that don't allow us to make inquiries into things like salary that traditionally in recruitment was a basis for what you would pay someone going forward. So we have to sort of reinvent the wheel and come up with a better way of gathering information that was seemingly simple to get prior to these new laws being enacted. My takeaway to clients is to stay close to your law department, particularly when you're recruiting, because it is an evolving landscape and the laws change almost on a daily basis.
Thanks, Andrew. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.